Hi guys, welcome to Sheria. Sheria is a platform that educates the ordinary mwananchi about the law so that we can equip and empower you. So today, we continue with the series we started about land transactions. If you're not up to date, you can go to the previous videos and just catch up so that you're not left behind. We got you. Today, we are looking at the sale agreement. What is a sale agreement? When it comes to land, you need to know we don't do transactions kienyeji. It has to be in writing. So we said first thing is due diligence. After due diligence, now we can sit down. Ideally, get a professional, get an advocate to reduce the contract into writing. This is what now we are calling the sale agreement. This should capture a lot of things, but we'll just focus on what you need to watch out for when it is a sale agreement. And of course, your advocate should be able to help. The first and the most important thing, money. Purchase price, payment. A word of caution, make sure you don't pay the entire money at the beginning. 2, make sure you don't pay the purchase price to the vendor or to the seller directly. Let me explain why you don't want to pay at the beginning. You can imagine the property is worth 50 million and then you have paid 50 million and then the vendor disappears or the seller disappears before transaction is completed. You don't want to lose your hard-earned money. I mean, land is not like paper. It has to be very specific and make sure, again, you pay it in installments. Especially, for example, if you're buying property off plan, like what most developing companies do, they advertise a property in the TV, in the newspaper, or on radio, inviting people to buy. After you've done your due diligence, what you do is you want to make sure that the contract states that you can pay in installments. For example, if the property is to be built, we can space out the money and make the installments when we can see a milestone on the property. This is protecting yourself as a purchaser such that you're not paying the entire money and then 3 months, 4 months down the line, we are just seeing the construction site bare. As a matter of fact, weeds ndio zimeendelea kugrow. Very painful and you don't want to do that. That is why we pay in installments. And you don't pay in installments until the last minute. No. We pay and we leave a residue of amount that is supposed to be paid at the completion stage. We'll explain that later. But just to pass through this, completion is when we are completing the contract. So, like how you go and buy a motor vehicle, when I give you the logbook, you give me the money. I don't give you the logbook and then and we don't necessarily trade the documents. We want to make sure that you are not exposed to risk. So that is why you leave a portion of the money to be given later on with the requisite title documents when we are completing the contract. Secondly, we want to make sure that the money that we are paying is held by the advocate. You see the importance of having a professional. If I'm paying 50 million and we are buying this property, we are to complete it maybe in a span of 6 months. Anything can happen in 6 months. What you want to do, make sure both of you ideally have an advocate. If me as a purchaser, I'm paying 30 million, for example, I want this 30 million not to go directly to the vendor. What if he disappears before we complete the transaction? Make sure that the vendor's advocate, or the seller's advocate is the one who's holding the money. So that in the event that something goes wrong, I can be refunded, easily refunded. So most advocates, as per the law, are required to have a client account. This client account is a separate account where they keep client money. It's called an escrow account and it's supposed to just be for the client. So you see, it's like you're protecting your interests such that money is not going directly to the vendor. It's going to the vendor's advocate. If default happens, you have a fallback plan. So that is why we're saying 1, make sure you don't pay the money directly to the vendor, and 2, don't pay the full amount. You're protecting your interest. We said money is very sensitive and we're making sure you get value for your money. Still under the sale agreement, I've talked about default. Again, remember land is not like a kienyeji transaction that we complete in 1 day, 2 weeks, or a month. Especially if you're buying the property, it will take a while. So something could happen. In the event something happens, even the purchaser might not have the money as anticipated. What would happen? We need to put in these clauses that protect our interests, the default clause. For example, as the purchaser, I need to know if I default. Most of the time, the law states that I lose or I forfeit 10% of the money that I've paid. See, 10%, depending on the amount, can be very costly. If you're buying property that is 500,000, 10% is 50,000, if I'm not wrong. Clearly, I didn't do math. That's why I went to law. But yes, 10% for 50 million, that's a hefty amount of money that you don't want to lose. So that is why make sure you put yourself in a situation where even if you're paying one, you know you get the money. If you don't have the money, the bank can come in, and if you get a professional again, they can draft something known as a professional undertaking, involve the bank, then the bank can be able to help finance, then you pay the bank pole pole. So no need to worry. Again, a default clause is there to protect us in the event something goes wrong. God forbid, even if the vendor dies or if the purchaser dies, there's something that we need to know that we're protected by the law. Another clause that we want to talk about would be completion. Completion is found in the sale agreement, and like the name simply suggests, how we are completing the contract. On the part of the purchaser, we said tunabakisha a specific amount of money that we pay at the end. Then the vendor is supposed to come with the original title documents. I'm talking original title documents, not copy of a title. Copy we dealt with when we were dealing with the investigation stage. Now we are dealing with the original. They're coming with the original. Similar to how you'd be buying a motor vehicle, you come with the original logbook. This is also accompanied with specific forms and consents, depending on the nature of the property. So you see, for example, if the property is in Kajiado, we want the title to show that the property is in Kajiado and it's original, the registry, the details, etc. They're also supposed to come with the consents. An example of a consent would be the Land Control Board consent. Another consent is if the property has been leased from the government. There could be specific properties where the government actually has a say. In this scenario, we want consent from the National Land Commission. So what I'm trying to say is the completion documents that the seller is coming with depends on the title. So I cannot specifically pinpoint that this is what they're supposed to bring. But make sure, again, with the advice of a professional, they're coming with all these requisite documents, because these documents is what we are going to lodge at the registry. Then the registrar will convert the name in the title from the old vendor or the old seller now to you as a purchaser. Then we said after that, we do a post search registration to confirm everything is okay. After everything is okay, now we can tell the vendor's advocate or the seller's advocate to release the money back to their client, because now we're okay and we are set and the title is in our name. Another thing that we want to talk about under the sale agreement that is very crucial: taxes and levies. So there's usually a question that I have bought land, but I still have to pay some sort of levies to the government, land rate and land rates. What happens is, depending on where your property is located, you will still need to pay land rates to the government. What is a land rate? It's a levy or a fee you pay to the government annually, and then you get something known as a land rates clearance certificate. It is because your property is located somewhere and you're getting specific services from the government. For example, security, sewerage, running water, these things that ordinarily you'd not find uko Ushago or in an agricultural area, the government is giving you, and as a result, they charge you. This charge or this fee is what we're calling the land rates. So that is why at the end of the day, even if you bought property, you still need to make sure you are investing in the property. You still need to make sure you're keeping up to date, you're maintaining the property. It's not that you're throwing the title somewhere in a safe and then now you can relax. No. We still need to practice due diligence. Please don't buy property if you do not have title or if you cannot see a title. No title, no transaction. That's what I tell all my clients. The minute the client is saying, oh, or rather the seller is saying, oh, my title is ABC XYZ, that's a red flag. Bare minimum, make sure in every transaction we have title to this property. If you're buying off plan, if you're buying apartment, if you're buying a flat, you're not relying on the head title or the mother title. We are making sure that this specific unit has its own parcel of land, has its own title. So that now when we are going to register, the vendor is not giving us excuses. We need our title, we are going to register, and it's a smooth process. So that's part of due diligence. An overview, again, like I mentioned, For the sale agreement, we want to make sure that we have captured everything. Again, we cannot exhaust all this in an episode, but what I'm trying to say is make sure if it is important, have it written, have the advice of a professional. Because what the law states is if it is not in writing, if it is not in the sale agreement, it does not exist. So assuming you have bought property and you've bought it from someone who intends to subdivide the property, meaning only the head title or the mother title, but they want to sell various portions to various people. But unfortunately, they have not yet processed the title for that specific portion or unit they're selling to you. But peradventure, you have already paid the full amount of money, but you have not processed the title. And then, the typical Kenyan style, we buy land, tunaiacha, tunasahau, and then we go, and then maybe a few years down the line, we come and check on it. And then lo and behold, when you're checking up on it, someone has even constructed because they were assuming this land was idle. This land is vacant, so we can build up on it. So how does the law protect you in such a scenario? What the law states is, when it comes to land transactions, it has to be in writing. Make sure, if imefika hapo, did you have any transaction, any record showing that you paid this person money? So if so, yes, the first thing that I advise you to do is register caution before go to court. A caution, again, we're saying we are claiming interest over this property so that they cannot sell it to another person or to another party. Unfortunately, you'll also have to go to court, which is a long process. And chances are, depending on, again, the facts of the case, you could get your money back. Or if, again, justice tilts to your favor, you can be able to claim a remedy known as specific performance. Specific performance is where the court can mandate this person who sold the land to you to actually sell this specific property to you. Then what I would recommend, after you have sold it legally, make sure you have a title to the property. Because remember, no title, you're not. If you don't have title, you're not the owner of the property. That's one way of protecting yourself. Another way, inversely, please make sure if you bought land, whether you have title or not, if you bought land, enda inspectingi. There's something known as adverse possession. This is where a third party can actually come and claim title to your property because you have been neglecting this property. If a third party has come to this property and lived on this property for a continuous period of 12 years, they will go to court, and the court will actually, after meeting all the legal requirements, will actually give them your title so they become the legal owner. What I'm trying to say is, make sure your land is not idle. Make sure someone is not on the property for a continuous period of 12 years. 12 years might look like a long time, but we all know in Kenya, we buy land and then we forget. You have gone, maybe you have done other things, and then 12 years down the line, someone is serving you with court orders or with court papers claiming to be the owners of this property. Mind you, the court will state that this is the legal owner if they've met the threshold again, because what the law is trying to discourage is people kulalia their rights. So I hope you're now more equipped, more empowered, even as you go about your day with buying and the selling of property. That's all we had for today. Again, if you have any questions, feel free to leave it at the comment section down below. We'll be able to address where need be. That's all for today. Don't forget to comment, like, share, and subscribe. Until next time, bye.